I can see you now. I love the purple.
Thank you.
You know, it's my favorite color. Although I have on green today, purple is my favorite color. Let's see. I can't see it. Is your client giving testimony?
No, Your Honor, it's just going to be argument since we have 10 minutes.
Okay. All right. And I have your exhibit. Okay, enjoy. You'll have to let me know when you're ready. Are you connected? Let me check that. It doesn't say I am yet, but I think it'll catch on. And Attorney Patino, Attorney Mitchell is present here in the courtroom.
Okay.
It connected to well, no, it's not connected. I'm saying the Wi-Fi connected to the DC. It's fine. Let me do it real quick. Yes, I can. Ready to. All right. We're on the record and calls number DF 24000022. Councils, will you please announce for the record?
My name is Erica Bettino, and I represent the movement, Jerry Green, in this matter. State bar number 240-74866.
And I'm Charcella Mitchell, attorney for Shamir Green, the petitioner in the underlying matter.
Thank you. All right, we're set here today on a motion for new trial filed by you, Attorney Patino, on behalf of your client, Mr. Green. The court has had an opportunity to review the motion for new trial, and you all will be giving argument. You all have 10 minutes aside. Prior to going on the record, there was an exhibit that was tendered that was pre-admitted. It'll be admitted at this time. So moving to exhibit 1 will be admitted. Attorney Patino, would you like to make an opening statement?
Yes, Your Honor.
Okay, you may proceed.
Thank you, Your Honor. This trial was held on October 30th of 2025 in your court, and there was a final order that was entered on February 24th of 2026. The motion for new trial was filed on or about March 24th of 2026, which makes it timely within that 30-day time frame that we are required to file this. In addition to that, the arguments that are going to be presented to the court today would show that the ruling that was made and entered on February 24th of 2026 is legally and factually insufficient in order for the court to have made a just and right division of the property. And I would like to start my argument presenting the following grounds for that argument, Your Honor.
You may proceed. Oh,
The
is that
first,
part of your opening?
no, Your Honor, I'm done with my opening.
Okay, let me move over to Attorney Mitchell. Would you like to make an opening?
No, Judge.
Okay, you may proceed, Attorney Patino.
Yes, Your Honor. The first argument I'd like to present to the court has to do with Texas Family Code Section 7.009. There was a claim for constructive and actual fraud on the community in the actual pleadings, and there was a portion of testimony that was presented concerning the tax fraud that Mr. Green was convicted of by the IRS, and he did some prison time, federal prison time, for about a year. Well, under the code, the court has to make a specific finding that there was fraud on the actual community in this in order for the court to even consider that in making a just and right division in the divorce proceeding and in the community funds. In this situation, there was not an actual finding in the final decree of divorce of any kind of fraud, even though it was brought up and was implied in the actual proceeding. In order for the court to find that someone has committed fraud upon the community, there has to be a finding that there was a transfer, a gifting, or unaccounted community funds in the actual marriage that was actually made by one person and distributed community funds that were not basically without knowledge or consent of the other spouse. In this situation, none of that occurred because the actual fraud that occurred was with the tax situation for the business that Mr. Green was actually involved in. So the only fraud that occurred was tax fraud directly with the IRS that didn't involve the community or disposing or gifting or transferring of any community assets. In addition to that, the actual lien on the community is just for Mr. Green's portion of his community property division. As the court knows, we have been working on getting the lien release on this, and the IRS is only interested in Mr. Green paying restitution and taking his 30% of what was awarded to him in the divorce. So it didn't affect any of the interest or community portion of Miss Green's in this. So if the court did base their decision on awarding a disproportionate share based on any allegation of fraud, it was not met per the statute I just quoted. My second argument is that per Texas Family Code 7.008, in dividing the estate in a divorce, the court may consider tax obligations. In this situation, I am going to cite Bacchus versus Bacchus. That is BACCUS, and it's 808 Southwest 2nd 694. And this is the appellate court in Beaumont, 1991, and there was no writ on this. And I'm going to quote that case, which says tax consequences stemming from the division of property as well as any unpaid tax liabilities are proper factors to be considered by the court in deriving at a fair and just division and division of community properties. Furthermore, it is reversible error for a court to refuse to consider tax liability particularly when it is a substantial and one of the spouses is without means to pay the obligation. In this situation, the court awarded Mr. Green 30% of the estate. Basically, it was 30% of the equity minus some mortgage payments that were awarded to be deducted. A 2020 BMW vehicle, his personal property, and a non existent IRA and 401k. There was testimony that the alleged IRA didn't exist. It was a savings account that had money in it that had already been spent. So essentially, Mr. Green was awarded just equity in the marital residence. Ms. Green was awarded the majority of the assets. She was awarded 100% of her 401k, which had over 600,000 in it. She was awarded the rent house, which was valued at probably over 350,000. The values on that are not sure. There wasn't a lot of testimony presented concerning the values of those properties, and the marital residence, which is also worth about 350,000, in addition to vehicles, her personal property, and the majority of any tax liability was awarded to Mr. Green. So in this situation, the court awarded Mr. Green a very little amount of the assets in order to be able to pay the substantial amount of tax debt, which is over close to $2 million in the tax debt that Mr. Green was ordered to pay in restitution for the tax fraud. In addition to that, the $30,000 that what resulted from a joint filing of tax returns that were filed by Mr. Green, including his spouse, in the situation. So the disproportionate share and the division of property gave Mr. Green very little in order to be able to pay the tax liabilities that he has in this court. In addition, there is another case I'd like to cite, Richardson versus Richardson, 424 Southwest 3rd 691, El Paso Appellate Court, 2014, and there was no petition on this one. There's a two-pronged test to determine whether the court abuses discretion. Number one, did the trial court have sufficient information upon which to exercise discretion on a division of property and debt? And two, did the trial court abuse its discretion by making a property division that was manifestly unfair or unjust? In this situation, the court did not have current information on anything that was actually divided. There was not any appraisals done for the marital residence located on Valentino Way, and there was not an appraisal on the rental property that was awarded to Ms. Green. The only thing that was presented was a tax appraisal, property appraisal from 2024 for the Valentino property. The 401k information for Ms. Green was from June of 2025. That was the 401k statement that was presented. The trial was in October of 2025. The inventory and appraisements were entered into court, but without any supporting documentation as to where the values of anything that was listed on there was given. The court actually asked Ms. Green if she had current information on her 401k, which she did not at the time. She only had what was presented to the court, which was a June 2025 statement. In addition to that, there was nothing presented regarding this non-existent IRA or 401k that Mr. Green was awarded. And there was very little that was presenting concerning the debts that were actually awarded to Mr. Green, other than the tax liability and the supposed tax returns that were filed that were never presented to the court, as far as the $30,000 that he was awarded that he had to pay. So the court made decisions on outdated information and insufficient information because very little was presented to the court regarding what was divided. In addition to that, the court awarded that Ms. Green would be reimbursed for mortgage payments from August 2023 to, I believe, October of 2025. And Per Texas Family Code Section 3.409, non-reimbursable claims include living expenses of a spouse. So a mortgage payment would be considered a living expense. So the fact that the court awarded Miss Green reimbursement on mortgage payments that, one, are considered living expenses,
Also,
two, they're,
you're out of time.
thank you, Your Honor.
You're welcome. Attorney Mitchell?
Judge, before I begin, I would like to first point out the fact that there's been no findings of fact, and no conclusions of law. So the basis by which this court has made their decision is unclear. And when there are no findings of fact and conclusions of law, the Supreme Court has held that the court must presume the trial court made all findings necessary to support the judgment. Judge, before we had this trial, we both attorneys had to attend an exhibits conference. We entered all of our exhibits into the court's record. We stipulated to which exhibits will be entered and which exhibits will not. Before we actually came to trial, we exchanged both discovery, we exchanged inventories and appraisals, which included all supporting documentation that was necessary, that's required in an inventory and appraisement. So both parties were made very well aware of the size and the amount of community estate, and that was also presented to the court through the evidence that was presented and actually entered into the court's record. Opposing counsel goes on to say that, I'm sorry, I'll go back. Trial courts have been given a wide discretion in determining what is considered a just and right division under the Texas Family Code. Opposing counsel goes on to make these claims that there's been a claim of fraud. And going through the record that's been presented as exhibit 1 in this case, fraud was mentioned a total of 16 times throughout this record, and 9 of those times was mentioned by Mr. Green's attorney when he was asking my client about whether or not her putting her mom or using her mom as the beneficiary on her 401k was considered a breach of her fiduciary duty and committing fraud. There has been no findings of fraud. My client did not, her testimony was not based on fraud. There's been no actual finding that this court's made this decision in dividing the community estate based on fraud. Opposing counsel cited Backus v. Backus with regard to the division of property, but the opposing counsel didn't bring up the fact that there are certain Murph factors that are considered, have to be considered in determining whether or not there should be an unequal division of the community estate. And that all goes back to whether or not the court made any findings with regard to whether or not there was fraud, whether or not that support the court's decision. And in this particular case, opposing counsel did not file any findings of fact and conclusions of law. So we have no basis by which this court made their decision. And because we have no basis by which the court made this decision, the court is inclined, in the appellate court, the Supreme Court is inclined to presume that the court made its decision based upon the evidence and the implied findings. So at this point, we're asking the court to just deny this particular motion for new trial. We're asking the court to find that this motion for new trial was frivolous, was not based on any factors, that the evidence was legally and factually sufficient to support the disproportionate division of the property, and to find that the division was just and right in accordance with the Texas Family Code.
Thank you, counsel. Well, Attorney Patino is out of time. Did you need to close, or was that it? Okay. The court will deny the motion for new trial.
Thank you, Your Honor.
Thank you all.
And here's the turning point, because the defense comes in calm, controlled, and deadly precise. Attorney Mitchell doesn't panic. Instead, he flips everything. He points out something critical. There were no formal findings of fact or conclusions of law. And that changes everything. Because legally, when that happens, higher courts assume the judge made the right decision anyway. That's a massive advantage. Then he reinforces it. Both sides had full discovery, full evidence exchange, full preparation. Nothing was hidden, nothing was missing. And suddenly, Patino's argument starts losing weight because now it looks less like injustice and more like disagreement. He shuts down the fraud angle, saying it was never officially found or used. And finally, he lands the finish. This motion isn't just weak, it's unnecessary. The decision was already fair, and just like that, the judge ends it. Motion denied, no second chance, case closed.